My name is Chad Rink, and I'm an attorney at Birch, Stewart, Kolasch, and Birch. Today I'll be speaking about In Re Thomas G. Packard, a Federal Circuit case decided on May 6, 2014. Thomas Packard is a pro se applicant prosecuting application number 12/004324. The application covers a coin change holder that is a thin plastic card with 4 different channels on its front surface for storing different types of coins. The examiner rejected the claims for indefiniteness and other reasons. For the indefiniteness rejections, the examiner rejected the claims for lack of antecedent basis or for being otherwise unclear. In response, Packard appealed to the Patent Trial and Appeal Board. The board affirmed the indefiniteness rejections. For the indefiniteness rejections, the board applied the MPEP standard that a claim is indefinite when it contains words or phrases whose meaning is unclear. After the board did not modify its decision in a rehearing, Packard appealed the board's decision to the Federal Circuit. The issue before the Federal Circuit was, what standard for indefiniteness should the USPTO apply to pre-issuance claims? Packard argues that the board misapplied the standard of indefiniteness by finding his claims indefinite on grounds that they contain words or phrases whose meaning is unclear. He argues that the claims would not have been held indefinite if the board applied an insolubly ambiguous standard to the claims. As such, a claim is not indefinite if a court can give any meaning to the disputed term in the context of the claim. Packard contends that the insolubly ambiguous standard for indefiniteness is mandated for post-issuance cases and pre-issuance cases. The Federal Circuit disagreed and held that when the USPTO has initially issued a well-grounded rejection that identifies ways in which language in a claim is ambiguous, vague, incoherent, opaque, or otherwise unclear in describing and defining the claimed invention, and thereafter the applicant fails to provide a satisfactory response, the USPTO can properly reject the claim as failing to meet the statutory requirements of 35 U.S.C. Section 112, second paragraph. The satisfactory response by the applicant can take the form of a modification of the language identified as unclear, a separate definition of the unclear language, or, in an appropriate case, a persuasive explanation for the record of why the language at issue is not actually unclear. The Federal Circuit determined that Packard did not provide a satisfactory response to the indefiniteness rejections. Rather, Packard ignored some rejections entirely and only offered brief explanations of what the written description showed. Packard did not fix or amend the claims or traverse the rejections based on the claim language. The Federal Circuit concluded, in some cases, it is difficult enough for courts to construe claims when the draftsperson has made every effort to be clear and concise, let alone when the claims have readily observable ambiguities or incoherencies within them. As such, the Federal Circuit affirmed the board's decision. Thanks for joining me, and I hope you learned something today. Stay tuned to bskb.com for more upcoming videos of interesting cases and other commentary on intellectual property.